Good morning. We have seen fundamental rights, that is from Articles 12 to 30. And when it comes to Article number 31, it talks about right to property, and it has been deleted through 44th Amendment. These things we have seen. But with respect to Article 31, there are some more points for the discussion. We'll have it a detailed discussion when we go for the revision. That is from tomorrow. Now, the most important article of the fundamental rights, or rather in the Indian Constitution, is Article number 32. I was telling you in the previous class that fundamental rights chapter, that is part 3 of the Indian Constitution, is considered to be the most criticized part. And Dr. B.R. Ambedkar has given highest importance to part 3. And out of these articles from 12 to 35, Dr. B.R. Ambedkar has given highest importance to Article 32. According to him, Article 32 is considered to be the heart and soul of the Indian Constitution. What is the meaning of this? According to him, we are giving highest importance to fundamental rights, and if there is no article called 32, there is no value for the Constitution, there is no value for the fundamental rights. That's the reason why he used the statement heart and soul of the Indian Constitution. Now, we already understood certain points that these fundamental rights are the basic rights of the citizens. But because of any reason, if any of the fundamental right is violated, then what should be done? What should be done is mentioned under Article number 32. Meaning, for the violation of the fundamental rights, we have every right to approach the judiciary. When it comes to the fundamental rights, we have every right to question either in the Supreme Court of India or in any high court. We have every right to move Supreme Court under Article number 32, and we can have every right to move High Court under Article number 226. Now what will happen? Generally, whenever we approach the judiciary, we approach through a petition. And through the petition, meaning, what is the meaning of petition? Petition is nothing but we are bringing an issue to the notice of the honorable court so that the court will look into that issue. Until and unless it is not coming to the notice of the judiciary, judiciary also cannot take any action. Now, because somebody has realized that there is a violation of his fundamental rights, then he needs to approach either Supreme Court or High Court. And whenever we approach the court for the violation of the fundamental rights, the court will issue something called writs. Whenever I use the word writ here, writ means it is a written document. It is just like a notice. The notice will be issued by the Supreme Court and the High Courts to the concerned person or to the concerned office for the violation of the fundamental rights. During the time, the concerned person or the authority must come to the judiciary and give the explanation. This is how the judiciary comes into the picture for the protection of the rights of the people. Hence, in the absence of Article number 32, we don't have a mechanism to fight for our fundamental rights. Of course, we are fighting through the judiciary in India. That is the reason why Article number 32 plays very crucial role. And in Article number 32, 5 writs are mentioned. We are going to have a discussion regarding each and every one now. So these writs are Habeas Corpus, Mandamus, Prohibition, Certiorari, and Quo Warranto. So these are the 5 writs that are available, and depending on the situation, the court may issue any of these writs. And what are the effects of these writs? So we'll try to understand, so one after the other. So I'll open the document now. I'll have a discussion with you. Kindly see here, we have already seen 5 fundamental rights and we understood what is the meaning of this each one. Once we feel that there is any problem with respect to our fundamental rights, if we feel that they have been violated because of any reason, so during that time, so we'll be approaching the judiciary. So the judiciary is coming to the picture. It is issuing the writs. Writ is a written document. So now we'll see what are these writs. We'll try to have a discussion one after the other. Now, first one, look at this. The Supreme Court and High Court can issue the writs. Right to move Supreme Court for the enforcement of the fundamental rights, including the writs of Habeas Corpus, Mandamus, Prohibition, Certiorari, and Quo Warranto. So these are the 5 writs that are available. Under Article number 359 of the Constitution of India, it provides the right to move Supreme Court, which can be suspended during the national emergency. This point let us understand when we talk about national emergency. For time being, just leave it. Don't bother about this point. Next, Supreme Court is considered to be the defender and guarantor of the fundamental rights. Now, look at the next one. According to Dr. B.R. Ambedkar, Article 32 is considered to be the heart and soul of the Indian Constitution, meaning this particular statement is signifying, it is enhancing the significance of Article number 32. Though we have so many articles under the fundamental rights, which are trying to provide so many basic rights to the people, until and unless we don't have the remedy if something happens to our fundamental rights, there is no meaning for the whole concept of the fundamental rights. That's the reason why Article 32 has been highlighted by the father of the Constitution of India, that is Dr. B.R. Ambedkar. Now, so look at the first one. So one after the other, we'll have a discussion here. Now, let me talk to you regarding the first one, that is habeas corpus. Now, look at this. Kindly see here, when I am talking about the writs here, the writs can be issued by the court either to an individual or to an authority. Certain writs can also be issued even to the private persons, meaning even against the private people also. Sometimes the court will come into the picture, the court will issue the writs, but otherwise all the writs can be issued against the state. State means, you know the meaning of this, Article number 12. So because of any activity of the state, if we feel that our fundamental rights have been infringed, we have every right to approach the judiciary, and judiciary will come to our protection. That is the basic idea. Okay. Now, let me talk to you regarding the habeas corpus. When I say habeas corpus, the meaning of these words is that produce the body. Body in the sense, it is a person. The person is missing. The person is not available. During that time, if the relatives or the friends of that person can approach the judiciary can provide a remedy. That is the reason sometimes if you see, certain kidnaps will take place. So kidnap is nothing but restricting the movement of a person and putting him in a closed room and keeping him there and detaining him illegally. That illegal detention may happen either by a private person or a public person. What do you mean by public person? Public person is a person who is a government authority. Sometimes here, when it comes to the kidnap or something, these are the private people, these are the anti-constitutional elements, they perform such type of activities. Detaining a person illegally is nothing but a violation of his fundamental right. Otherwise, we have seen the right to movement. We have every right to move from one place to the other, and detaining somebody forcefully is nothing but his violation of his fundamental rights. This act may also be done by even the state. Sometimes you'll see police on the name of this interrogation or on the name of this inquiry, they will detain a person and they don't produce the person before the court within 24 hours. Obviously, that is considered to be the violation of the fundamental rights. During the time, if the relatives or the friends of that person approach the judiciary will issue a writ called habeas corpus. When the writ is issued to the police or the private person, it is an order that is coming from the Supreme Court to produce the person who has been detained before the Supreme Court within a period of 24 hours. Once it is issued, the person has to be produced before the judiciary. That is the basic idea, right? I'll show you the document now. I'll show you some points what I have with me. Now look at this. Habeas corpus stands for produce the body. It is issued by, kindly remember, it is issued either by the Supreme Court or by the High Court, depending on to which court we have moved. It is an order issued by the court to a person who has detained another person, meaning X detained Y. Okay, so to produce the body of the later before it, kindly remember one thing: if a person is already detained, physically he cannot approach the judiciary. Number one. Number two, on his behalf, anybody can approach the judiciary. But the only thing is that judiciary requires the evidences. Otherwise, some people may misuse the concept of habeas corpus also. That's the reason whenever anybody is approaching the court to request for issuing the habeas corpus, the person is expected to go to the court with enough evidences. So the court should get satisfied. Then only the habeas corpus writ will be issued. So now if I can read the statement once again. This is an order issued by the court to a person who has detained another person to produce the body of the latter before it. Hence, this is considered to be against arbitrary detention. Arbitrary detention means intentional detention, and it can be issued to a private person or public authorities. Kindly remember, habeas corpus is the only writ which can be issued to both the private persons and also the public authorities. Am I clear? Right? This is number one. So kindly remember this: habeas corpus is against the illegal detention, arbitrary detention. A person can be arrested by the police, no issues, by issuing the arrest warrant, and immediately after that, he has to be produced before the court within 24 hours. Otherwise, that is considered to be arbitrary detention. And when it comes to the private cases, it is considered to be again the kidnaps and something, they are considered to be illegal confinement, arbitrary detention. Okay, now the second one we'll see, that is called mandamus. Look at this mandamus here. When I use the word mandamus, this is nothing but to command. It is nothing but giving an order. So here, the judiciary is coming into the picture for giving an order to a public authority. What do you mean by this public authority? You look at any government official, every government official will have his own jurisdiction. When I use the word jurisdiction, this is nothing but an area of operations. What do you mean by this? For example, here in your locality, you have one electricity office, you have one revenue office, You have one police station. Examples I'm telling you. So with respect to any complaint related to the crime or something, we go to the concerned police station only. So meaning wherever you are living, that area is coming under the jurisdiction or coming under the area of that particular police station. Then only the complaint will be taken and the police will jump into the action. Single police station cannot perform the activities throughout the country or throughout the state or throughout the city. That is the reason why so many police stations have been established, and each police station has been given an area. That area is nothing but the jurisdiction. With respect to any crime that happens in their locality, the concerned police station authorities should take the action. Meaning the area has been demarcated. That area is called jurisdiction. Similarly, see here, for example, you may have sometimes the power issues. We have paid the power bill. Even then, the power supply is not there. During that time, we'll go to our respective electricity office in our locality only, but we don't go to any other office which is present far away. Maybe because we know our area is located in the jurisdiction of the so and so electricity office. So accordingly, the concerned officials will come and try to rectify our issue. This is the basic idea. Meaning, being the citizens of India, we have every right to get our work done. And who are all the government officials who are present, they are meant for serving the people. They have to look after the welfare of the people, see that the people should not be troubled because of any reason. This is the fundamental idea with respect to the concept of public services. But sometimes what happens, some government officials may be lethargic. Maybe they are looking for some bribe. Whatever may be the reason, but our work is not getting done. If our work is not getting done, then what should we do? We can approach the judiciary with the evidences. So what is the meaning of this? Whenever we approach any government authority, we approach through a requisition. We approach through a petition. And the petition has to be given to the concerned authority. At the same time, we need to take the receipt of our complaint. It is nothing but we take the Xerox copy of that and we request the authorities to put a signature on this Xerox copy. That itself will become an acknowledgement. And tomorrow, because of any reason, if our work is not getting done, then obviously we have every right to approach the judiciary. Since evidences are available, the judiciary gives the direction to the concerned public authority and our work will get done immediately. Otherwise, the concerned public authority may be suspended or the judiciary will give the directions to the head of the department to take action against the concerned public servant. In the absence of all these, the citizen cannot be protected. That is the basic idea. That's the reason, as a citizen, we have every right to get our work done by the government. So this is the basic idea. Otherwise, we can request for interference of the judiciary, and that comes into the picture through a writ called Mandamus. Hopefully, I'm clear. I'll show you the document now. Look at this. It is issued to a public official asking him to perform his official duties that he has failed or refused to perform. Very, very important, that he has failed or refused to perform. Next one in the brackets, kindly observe this one. This cannot be issued against the president or governor or chief justice of a high court or against any private person. Very, very, very important. So these are the authorities against whom the mandamus cannot be issued. Meaning, mandamus is issued only against the government officials and not against the private persons. Only habeas corpus can be issued to both public and private persons. But when it comes to mandamus, it will be issued only to the public authorities and not to the private persons. Next one. Next one. Let's look at both of these. This is prohibition and certiorari. Let me tell you some points here. When it comes to this prohibition and certiorari, these two are issued by the higher judiciary to the lower judiciary. I was telling you in the previous class that we have hierarchy of the courts. Supreme Court, High Court, District Court, Sessions Court. Like this, we have the hierarchy of the courts. Kindly remember, in this particular session, I am going to use the words higher courts and lower courts. I am using the word higher, Higher. When I use the word higher courts, these are the courts which have the right to issue the writs. In India, already we have understood, Supreme Court and High Court will have the power to issue the writs. That's the reason when I use higher courts, I am combining these two courts. And remaining all other courts are considered to be lower courts because they don't have the right to issue the writs. Hope you are getting me. Supreme Court and High Court are the higher courts. Remaining all courts are considered to be the lower courts. Now, sometimes what will happen, the lower court, because of some reason, there may be a violation of its jurisdiction. Examples here, just now I gave you one example like police station and electricity department. In the similar manner, we have so many courts that are present in India. It is basically the administration will become so easy. So that if any crime or if any incident takes place in a particular locality, it is always better to take the case to the concerned judiciary. So this is the place where the lower courts will come in handy. If we start taking every case to the High Court and the Supreme Court, it will kill lot of time of the judiciary at the highest level. That is the reason for the quick disposal and easy disposal of the cases, the lower courts have been established. Just like any other office, like police department or the electricity office, even the judiciary will also have its own jurisdiction. And when I say this jurisdiction, again I am talking about the area. You might have heard this word. For example, here, the jurisdiction of the Supreme Court is entire India. That is, all 29 states and 7 union territories will come under the purview of the judiciary. That is the Supreme Court. But when it comes to the High Court, the High Court's jurisdiction is much smaller when compared to the Supreme Court. High Court jurisdiction is restricted to either one state or more than one state, either one state and including one union territory. So this is defined. This is very much defined. So beyond this, the High Court cannot exercise its jurisdiction. Similarly, if you come to the lower level at the district level, I have a district court. And the district court will function in such a way where it can accept any incident that took place in its district area, in its jurisdiction only. Other cases which are falling under the jurisdiction of some other court, you cannot take the case to some other lower court. But sometimes the mistake may happen and a lower court might have taken a case which is not falling under its jurisdiction. During that time, the High Court or Supreme Court will issue a writ called prohibition. Whenever the writ prohibition is issued, the meaning of this is that it is nothing but giving a notice to the lower court and asking the lower court to stop the proceedings immediately, to stop conducting inquiry immediately, because you are inquiring, you are proceeding with a case which is not falling under your jurisdiction. During that time, the prohibition will be issued. Immediately, the lower court has to stop its proceedings. That is the basic idea of the so-called prohibition. Sometimes what will happen? The lower court might have given the judgment also. In order to nullify the judgment of the lower court, the higher court will issue another writ, and that writ is called certiorari. Prohibition is for stopping. Certiorari is to nullify the judgment of the lower court, and certiorari is also meant for transferring a case which is there with the lower court from that lower court to some other court. That is called certiorari. Kindly remember, prohibition is to stop it, and certiorari is to nullify the judgment. Certiorari is also used for transferring the case from one court to the other court. Hence, two writs I have spoken to you now. One is the prohibition, second one is the certiorari. These two writs are issued by higher court only to the lower courts. No other authority is coming into picture. That is the basic idea with respect to the prohibition and certiorari. Kindly remember this, very frequently asked questions in the examination. Now, let me show you the document. Look at this. Prohibition is issued by a higher court to a lower court or a tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Certiorari, it means to be certified or to be informed. Again, it is issued by a higher court to a lower court or tribunal, either to transfer case pending with or to quash. This is not squash here, I'm sorry. So this is quash. So to quash the order of the later in a case. What is the meaning of this? Either you are transferring the case or you are cancelling the order that is given by the lower court. If you are stopping, it is prohibition. If you are cancelling the order, that is the certiorari. Kindly remember these points. Next one. Next one, we have something called quo warranto. What do you mean by this quo warranto? Look at this. By what authority? Quo warranto stands for by what authority? It is issued by a court to inquire into the legality of a claim of a person to the public office. What do you mean by this? Every government authority should hold an office, and he should be legally claiming that one. Sometimes the questions will be raised against the concerned authority's office. Say, for example, so I have the example here. You can just have a look at this. In the year 2001, the assembly elections have been taken place in Tamil Nadu. In that election, in this cases here, Ms. Jayalalitha, she got elected. She has been appointed as the chief minister. But for a person to become a chief minister, the constitution has provided certain things. The person is, number one, should be a member of the state legislature. Legislature means either assembly or the legislative council. But in Tamil Nadu, there was no legislative council. So only assembly was there. Hence, a person to be appointed as a chief minister must be a member of the assembly. But the constitution has given a provision saying that without being a member of the state legislature also, a person can be appointed as a minister. When I say minister, minister also includes the chief minister. So without being the member of the assembly, a person can be appointed as a minister. But within a period of 6 months, the person should become a member of the legislature. This is the provision that is given by the constitution. But during that time in that election, Jayalalitha contested from 4 different constituencies. And from 4 different constituencies, her nomination papers were rejected. That is the reason why she was not permitted to contest in the elections. But in that election, her party, AIADMK party, got the majority. Because her party got the majority, she became the chief minister. She has been appointed as the chief minister by the governor. But immediately after that one, in the Supreme Court, a petition was filed, and the request is that declare the appointment of Jayalalitha as null and void as a chief minister. And the allegation is that the constitution is very much permitting that a person can become a minister without being a member. But in this case, the intentions of Jayalalitha was very clear. She was trying to contest in the elections. But because of some reason, her nomination papers were rejected. But her party got majority, then she became the chief minister. When it has been questioned in the Supreme Court has issued quo warranto to Jayalalitha, and Jayalalitha had to step down during that time. Again, during that time, for a period of time, today's chief minister, Mr. Pannir Selvam, he also acted as a chief minister for some time during that time. Later, some cases that were against Jayalalitha, she has been acquitted by the High Court of Madras, and again she contested in the elections. Again she became the member of the assembly. Then again she has been appointed as the chief minister. So these are the things what happened in Tamil Nadu. So during that time, the Supreme Court has issued a writ called Quo Warranto. Supreme Court asked Jayalalitha on what authority. I'll just show you the document now. Look at this. Under Representation of People's Act of 1951, look at this. This is called a Representation of People's Act of 1951. In the main syllabus, we have a separate chapter for this. We'll have a detailed discussion separately. A person is allowed to contest from not more than 2 constituencies. In that year, the leader of AIADMK, Jayalalitha, contested from 4 constituencies: Andipatti, Krishnagiri, Bhuvanagiri, and Pudukottai. On November 20th, 2012, the Supreme Court quashed a criminal proceeding against Jayalalitha initiated for filing 4 nomination papers in the year 2001 assembly polls, and asked Madras High Court to re-examine its order to lodge the case against her. So this is what happened. Look at this. This is the information related to Jayalalitha. You can have a look at this very fastly. As per Supreme Court and High Court of Madras, as per Supreme Court, just a moment, yeah. Now, let's read now. As per the Supreme Court, the High Court of Madras did not consider the 2 reports of the returning officers. They were not considered while passing the order. The Supreme Court asked the High Court to examine the issue within 4 months. The Supreme Court order came in Jayalalitha's plea against High Court order to the Election Commission to register a criminal case. Look at this. All 4 nominations that were filed by Jayalalitha were rejected, as she had been disqualified from contesting the polls at that time due to her conviction in the Tansy land deal case. A former DMK MP, Kuppuswamy, moved the High Court against her, and the High Court in June 2007 directed the Election Commission to register a case, and the same was stopped by Supreme Court in July 2007. Look at this. The High Court held that the Jayalalitha's declaration in 3rd and 4th constituencies, Bhuvanagiri and Pudukottai, that she has not been nominated for more than 2 segments was false to her own knowledge and amounts to the violation of the section 33(7)(b) of RPA, as per which a candidate cannot contest from more than 2 constituencies. Meaning the allegation against her is that she willfully disobeyed this particular law. Okay, and when I come to this Representation of People's Act, we'll have an elaborate discussion on this one. Look at this. We have some more articles here. This Article 33. It talks about the Parliament is empowered to abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence forces, and other related agencies. What do you mean by this? If armed forces means we have Air Force, Navy, and our Army. Paramilitary, CRPF, ITBP, BSF. These are all the paramilitary forces. And remaining other intelligence forces and police forces here, their fundamental rights can be abrogated by the parliament. Because these are considered to be the strategically very important forces for the nation, they are not expected to go on strike. They are not expected to go on the agitation. If these people go on agitation, it will be a bigger risk and threat to the nation. Here is the parliament has every right to abrogate the fundamental rights of these members. Look at this note. Any law that is made by the parliament under Article 33 cannot be challenged in the court of law. Next, Article number 34. This provides for the restriction of the fundamental rights while martial law is in force in any area within the territory of the country. What do you mean by this martial law? Look at this. Sometimes any area in the country, maybe one district, two districts, three districts, or 10 districts, or few districts in one state and few districts in some other state. The situation will become so sensitive that it becomes very difficult for the government of the day to control the situation. During that time, martial law will be imposed in that area, and when the martial law is imposed, the army will become completely powerful in that area, and the people who are living in that area cannot enjoy the fundamental rights. Everything will be decided by the army. That is the reason Article 34 is important again. Martial law is mentioned in Article number 34. When it comes to Article 35, it is talking about the powers of the parliament. The parliament makes laws to give effect to certain specified fundamental rights shall vest only in the parliament and not in the state legislature. Look at this. As per the provisions of Article 35, the parliament prescribes residence as a condition for certain employments or appointments. You might have seen in certain cases, you will see residence is considered to be a qualification for certain jobs. You must be knowing what happens in your state or in your region, and that can be decided by the parliament. At the same time, the parliament also empowers the lower courts other than the Supreme Court and High Court to issue the directions, orders, and writs of all kinds for the enforcement of the fundamental rights. As of today, only Supreme Court and High Court can issue the writs. But when it comes to Article number 35, the Parliament is also empowered to permit the lower courts to issue the directions, orders, and writs of all kinds for the enforcement of the fundamental rights. Okay, and we have certain miscellaneous points here. You kindly go through these miscellaneous points on your own. So they are available in our site. It's kalyansir.net. Okay, and be thorough with all these things. These are all simple points I have given you. And I request all of you again, once again, go through this concept of fundamental rights. Be thorough on this. Okay, so tomorrow, so again, we'll go back to article number 12 and we'll try to look into all the articles in a very detailed manner so that it becomes easy for us to have lots of command on this subject. That's the reason why I am going for a revision. But before that, I want you to go through this for 2 times or 3 times or 4 times if possible. But with respect to the miscellaneous points I showed you now, that is present in kalyansir.net. Just open that site and read the document for 1 time or 2 times. Okay, and we'll meet tomorrow at 5 o'clock at the same time. So thank you so much for being with me this morning. Have a very, very good day.